14A District Court for County of Washington State District is now back in session. The Honorable Judge Jacob presiding.
You may be seated. Back out. We're back on the record.
Right out the gate, we're diving into bond motions, one side pushing for a lower bond, the other fighting to keep it locked tight. This isn't just legal poker, it's a high-stakes tug-of-war. And when denial of bond is even on the table, you know the allegations are no joke. Michigan law doesn't play around when it comes to deciding who gets to walk free and who waits behind bars. Let's break down exactly how that decision gets made, and what factors can tip the scales.
Case of the People State of Michigan versus Zachary Radcliff. In this case, there are, in essence, competing motions regarding the defendant's bond. The defendant is asking that his bond be reduced, and the people are asking, to the contrary, that his bond be not effectively, but denied in this case. The court rule is very clear and very specific in terms of when the court can deny bond to an individual. There's a statutory section which applies to it, as well as a court rule. Specifically, with reference to the court rule, the court may deny bond to a defendant that is charged with criminal sexual conduct in the first degree, armed robbery, kidnapping with the intent to extort money or other valuable thing. Thereby, if the court finds proof of the defendant's guilt is evident or the presumption great, unless the court finds by clear and convincing evidence that the defendant is not likely to flee or present a danger to any other person, or what one may say.
How the court keeps circling back to danger to the community. That's not just legal fluff, it's the judge's way of asking the hard question. If we let this person out, are we risking more victims? This isn't theoretical, it's real. What if someone in your own neighborhood was accused of this kind of behavior? Would you feel safe knowing they could walk out on bond tomorrow? That's the dilemma playing out in courtrooms across Michigan, and the stakes couldn't be higher.
Danger to the community. The court can take a number of factors into account, and I've given, I think, each side an opportunity to respond to the court's inquiry as to what was going to be important in terms of the court's deliberation. People have done, both parties have done an excellent job in laying the issues that the court needs to decide before the court. I would say that the people's rendition of the statements and stories, at least the minimal synopsis of the statements and stories of the alleged victims in the case, are indeed compelling to the court. And one of the first inquiries that the court had was, as the court sees the whole thing, what really is a grooming and predatory behavior as you see each of these incidents. The court does take into account also that the defendant's position within the church and access to the youth.
Here's where it gets chilling. The defendant allegedly used his role in the church to get close to youth. That's not just disturbing, that's textbook grooming. The kind of manipulation that hides in plain sight, wrapped in trust, cloaked in authority. It's the predator disguised as a protector. And when the court hears that, that's when the tone shifts. That's when the bench starts leaning in, looking past the paperwork and into the real threat. Because now it's not just about bond, it's about protection.
Play a factor in that, as it does in cases where there are like children involved and certain behaviors, threats, if you will, enticements, other things can come into play. What is also of note, something that the prosecutor brought up and I think does bear noting, is that the defendant's bond initially, when the initial charges were filed and the arraignment was set at the $3 million, the current bond that it is set at. Did not take into account the additional charges that came forth. So this is really, in essence, the first addressing of bond with the additional charges of the additional individuals.
Let's decode what's happening here. That original $3 million bond, that was before the new charges surfaced. Now, with multiple new victims stepping forward, the court's not just revisiting the case, it's reassessing the entire risk. Think of it like updating the scoreboard, except this isn't a game. The stakes are real. Freedom or jail time. Every new allegation shifts the balance. And the court has to ask, does the old bond still make sense? Or is it time to tighten the leash?
I say that because I want to make it very clear that any change by this court is not based upon it's based upon the motion, not based upon any abuse of discretion by the magistrate in terms of initially setting the $3 million bond. But the rules, in essence, well, defense counsel is correct in pointing out that one looks at an individual's release and their ability to have bond or to be in a position to post bond and not restrict their liberty, except under those limited circumstances. And then it is almost as if and it is up to the people at that point to show that the defendant should be incarcerated. In limited circumstances, that in some ways shifts the burden in looking at certain things shifts. For example, in a crime of treason, violent felony where the other predicates are met, and then in certain types of cases where there is an analysis of whether guilt is evident or where the presumption is great. Given what this court has heard and the motions that have been filed and the information that has been put before the court does find that there is a great presumption that the people have established a great presumption of the defendant's guilt in this case. I would also indicate that the court is taking into account that the behavior is indicated, at least is laid out here. And I don't know what would happen during the course of testimony, but what has been laid out shows, I don't even want to say classic predatory behavior, but it in a lot of ways is, where individuals are basically these victims are placed into that position. Certain threats, either said or unsaid, are then placed upon these individuals, and then these individuals don't come forth. As the proffer indicated that was put forth by the people, if that's true, and if the evidence, I should say, bears that out, one can see what the court is talking about with reference to an individual that is a young person who is forced to engage in sexual acts, who is then that next day has to see that.
Being a young victim terrified, vulnerable, and then seeing your abuser the very next day back in church, leading prayer, standing above you like nothing happened. That's not just trauma, that's a chilling power imbalance that doesn't go away. It's abuse, wrapped in reverence, silence, and control. No wonder the judge called this classic predatory behavior. If the allegations are true, should that kind of manipulation carry more weight in bond decisions? Should trust betrayed be treated as an even greater threat? Let us know what you think below.
That whole series of things is by design for a very good reason, because that stops this person from saying anything. Doesn't say anything to the parents, doesn't say anything to the people in church, doesn't say anything because of where this happens. And the longer that goes, it becomes more difficult for the person to say so. In just listening to that, looking at what's been laid out by the people, the court, as indicated, does find that there is a great presumption of the defendant's guilt. It then shifts to show by a higher standard than normally would be applicable in a bond argument of basically a preponderance of evidence, but it shifts to a clear, convincing standard to show that the defendant is not likely to flee or does not present any danger. And that really does shift, in essence, to the defendant to show that, or at least put forth some evidence to the court where the court could conclude that. This court does not conclude by any stretch of the imagination that the defendant is not likely to flee. The court believes that the defendant is in a position of potentially facing life sentences. That also there is a circumstance, and it's a bit unclear, a bit murky, but where he knows that he is subject to at least an investigation and flees, or at least leaves the state. Oddly, where the parents, or those that most likely would know where they are, where he is, don't know. And he is there. Counsel may make a good point that the very fact that if he were going to flee, that he comes back. Under what circumstances and for whatever his reasons are of coming back, I don't know. And maybe that's to be told. But this court views that as something where clearly the defendant has connections in other states that he could flee to. I think that the laying out of the number of victims, and not necessarily the numbers, but the number of the acts, make it more likely to this court that the defendant would flee or could flee to that. And the court does believe that he poses a flight risk. I also do believe, because I think it becomes a bit difficult when one is trying to address, does this person pose a danger to another person and or to the community? This court does believe that this defendant, given all of the circumstances that the court now has before, does pose a danger to the community. I've read all of the letters of support that the defendant does have, and people have good things to say about him. They have good things to say about his family. I make note of one thing that the prosecutor said, and it doesn't seem like it's much, but for this court it was much, where in talking with Michigan State Police, she either blurts out or says that her son is leading a double life or a separate life. I don't blame her for saying that. I think it may have just been something that she said when she sees everything. And I think that that's true in this case. And so I also think that there isn't given the magnitude of what the defendant is accused of in this case, that while the court has many tools at its disposal, the court doesn't have the, I don't think, proper tools that would be able to monitor and prevent the defendant from hurting other individuals or engaging in this behavior with other individuals. The only way the court would have to do anything along those lines is certainly to order that, but that doesn't mean that the defendant has to follow it. And then we don't know until somebody else's mental health and or physical health is damaged that it has occurred. And this court is not going to take that risk given the circumstances and what the court is looking at. Taking all of that into account and looking at everything, and now looking at this case with the number of charges, the number of alleged victims, the court does not believe that the $3 million bond, which was initially set, is an appropriate bond, and that under the circumstances, the court now has heard them and now knows the defendant's bond ought and should be denied. And so therefore, I will deny the defendant's motion to reduce bond. I will grant the people's motion to deny bond. Defendant's bond is denied.